Parliament has been given 24 months to remedy a constitutional defect on Section 18 of the Criminal Procedure Act. It relates to the right to institute criminal prosecution for sexual offences more than 20 years after an offence was committed. The Act doesn't allow for sexual assault victims to take their cases to court once 20 years have lapsed, unless, of course, it relates to offences such as rape or human trafficking. Well, the Constitutional Court yesterday confirmed a High Court order that the Act is inconsistent with the Constitution. To talk more on this, we are joined from our Pretoria studio by the Minister of Justice and Correctional Services Advocate, Michael Masutha. So good to have you, Minister. Thank you very much for joining us on the programme.
Good morning and morning to all the viewers.
So Minister, as the second respondent in the case, you actually supported the application for confirmation but rejected the applicant's contention that the order of invalidity should have immediate effect. What are your concerns?
Well, basically, yes, you're correct that in principle we were in full agreement with the application. We felt that it would be better that the court allowed us time to prepare necessary legislation to correct the defect, which we in the interim actually introduced in Parliament. However, in the light of this judgment, I think that our amendment may not be going far enough, in that my understanding of the judgment is that all sexual offences should not prescribe, and therefore we may have to revisit even the bill that's currently before Parliament in order to give full effect to the decision of the court.
Yeah. I know that you also asked for a longer suspension period to allow Parliament to actually effect remedial legislative amendments. But I think there's a big concern that enough harm has been caused to the victims and that Parliament should actually remedy the constitutional defect on Section 18 of the Criminal Procedure Act within the time frame that's given by the Constitutional Court.
Oh, certainly. The reason why we actually introduced a bill in the interim, even before the judgment came through, was that we wanted to remedy the situation as soon as possible, even prior to, the 24 months period. The 24 months period is a standard period that the court usually grants, sometimes shorter, Parliament, acknowledging the processes of public consultation over and above the actual drafting, making sure that the legislation is in proper form, etc. But like I said, we have in the meantime introduced a bill which is before the Portfolio Committee on Justice and Correctional Services. The reason we acted swiftly was also to beat the deadline of the closing date for submission of bills to Parliament this year, so that we do not miss the opportunity to correct the legislation in the current round. But clearly, with the judgment, we may need to tweak the bill even further to make it more precise, make it more precisely consistent with the Constitutional Court ruling.
Minister, this obviously was brought about by a group of women against Sidney Frankel. I think South Africans know this case quite well, who has since died. What's going to happen to their right to a full trial?
Well, look, obviously the law must first come into existence and take effect for those that are affected to benefit from it. So it is only after the Act has come into law correcting that situation that whoever is affected would be able to approach the court for appropriate recourse.
Yeah. Just in terms of other cases that have come to the attention of the Justice Department that are quite similar, how will they now be dealt with?
Obviously, if those matters have lapsed in that 20 years have since passed, the advice would be that as soon as this new amendments have taken effect, victims should approach the criminal justice system, by way of firstly laying a charge with a police station, that the starting point in all criminal matters, so that the police can investigate the allegations, and of course, if the matter is ready for prosecution, it is then referred to the prosecuting authority for prosecutorial decision, and then goes to court for trial.
All right. Okay, Minister, we'll have to leave it there for now. Thank you very, very much, however, for coming in and talking to us about this issue. There was the conversation that we were having there with our Minister of Justice and Correctional Services, Advocate Michael Masutha.